This Court has made clear that a party on appeal has to meet the same Article III standing requirements of injury caused by the action complained of and redressable by the relief requested by the party.
It seems to me there's injury here.
Well, Your Honor, I do not agree that the injuries alleged by the United States should be cognizable by the Article III courts, because those injuries are exactly what it asked the courts below to produce.
I mean, to go back to Justice Kennedy's point, we have injury here in the most classic, most concrete sense. There's $300,000 that's going to come out of the government's treasury if this decision is upheld, and it won't if it isn't. Now, the government is willing to pay that $300,000, would be happy to pay that $300,000. But whether the government is happy or sad to pay that $300,000, the government is still paying the $300,000, which in the usual set of circumstances is the classic Article III injury. Why isn't it here?
I do think, for purposes of the federalism issue, it really matters that all DOMA does is take this term where it appears in federal law and define it for purposes of federal law. It would obviously be a radically different case if Congress had, in 1996, decided to try to stop states from defining marriage in a particular way or dictate how they would decide it in that way.
Well, it applies to over, 1,100 federal laws, I think we were saying. So it's not — I think there's quite a bit to your argument that if it's a tax deduction case, which is specific, whether or not if Congress has the power, it can exercise it for the reason that it wants, that it likes some marriages, it doesn't like, I suppose it can do that. But when it has 1,100 laws, which in our society means that the federal government is intertwined with the citizens' day-to-day life, you are at real risk of running in conflict with what has always been thought to be the essence of the state police power, which is to regulate marriage, divorce, custody.
Well, Justice Kennedy, 2 points. First of all, the very fact that there are 1,100 provisions of federal law that define the terms marriage and spouse goes a long way to showing that federal law has not just stayed completely out of these issues. It's gotten involved in them in a variety of contexts where there's an independent federal power that supported that. Now, the second thing is the fact that DOMA affects all 1,100 statutes at once is not really a sign of its irrationality. It's a sign that what it is, and all it has ever purported to be, is a definitional provision. And like every other provision in the Dictionary Act, what it does is it defines the term wherever it appears in federal law in a consistent way. And that was part and parcel of what Congress was trying to accomplish with DOMA in 1996.
Well, but it's not really uniformity because it regulates only one aspect of marriage. It doesn't regulate all of marriage. I see an illogic in your argument. I hadn't thought of the relation between Section 2 and Section 3 in the way you just said. You said, now, Section 2 was in order to help the states. The Congress wanted to help the states. But then in Section 3, the Congress doesn't help the states, which have come to the conclusion that gay marriage is lawful. So that's inconsistent.
No, they treat them, which is to say they are preserving, they're helping the states in the sense of having each sovereign make this decision.
We're helping the states do, if they do what we want them to, which is not consistent with the historic commitment of marriage and questions of the rights of children to the state.
I think there so clearly is a federal power because DOMA doesn't define any term that appears anywhere other than in a federal statute that we assume that there's federal power for. And if there's not federal power for the statutes in which these terms appear, that's a problem independent of DOMA, but it's not a DOMA problem. So I'll assume we have federal power. Then the question—
Well, I think it is a DOMA problem. The question is whether or not the federal government, under our federalism scheme, has the authority to regulate marriage.